Well, howdy, y'all. Welcome to Uncivil Law. And for today's case, we have the case of what happens when you owe the government $8.41 worth of property taxes. Answer is they take your home and they sell it. And then they don't give you any of the money. But we're trying to figure out whether or not that's legal. This is the case of Rafalfi, LLC versus Oakland County. In this case, Rafalfi owed $8.41 in property taxes. The government seized his property. They sold it. And then they kept all the money. And Ralph Hoffey says, but I only owed $8. What about the other $25,000? The government says, yoink. So we covered this before when we covered the case from the lower levels of appeal. But this is the Supreme Court of Michigan trying to determine whether or not this is legal. Can you seize someone's property for $8.41 and keep all the money? All of it. Good work if you can get it, I guess. Let's find out if it's legal. Let's get started with this. Plaintiff Ralfifi, LLC, owed $8.41 in unpaid property taxes from 2011, which grew to the sum of $285.81 after interest, penalties, and fees. So it was $8, and you also owe us $280 worth of penalties and fees. Oakland County and its treasurer, Andrew Meisner, nice name in this case, right? Because of Meisner for a tax collector, great name. So they foreclosed on Ralphie's property for this delinquency, sold the property at auction for $24,500, which seems to be more than $285 last time I did math, but crucially retained all the proceeds, all of them. So you owed us $8.41. You owed us $8.41, which turned into $285. We sold the property for $24,500. And so we have a $23,700 excess. And we said, no, we don't. That's our money. And Ralph Hoffey says, what? But I have a $25,000 property. No, you don't. You owed us $8.41. We take it all. We take it all, baby. Yeah, that's what the government's plan was. Okay. The issue in this case is whether defendants have committed an unconstitutional taking by retaining the surplus property from this tax foreclosure sale, and these amounts that exceed the amount that was actually owed. All right, so let's learn a little bit about the backstory of this house and how this came to be. Rafalfi over here purchased this rental property for $60,000, so it's not going very well for him because he paid $60,000, but he failed to pay taxes on the amount due. Defendant mailed them a notice in delinquency of 2012. Ralphie sent a payment to 2012, yet this payment was insufficient for the full amount. So the defendant sent him a second notice, and he sent another payment. However, this was deficient by $8.41. I'm not sure why he can't just pay the amount due, but plus $2.26 in interest, penalties, and fees. So can we just send him a check for $10? No, because we don't want to do that for some reason. So on February the 1st, 2013, the defendant sent us third notice, like we need another $10. And this amount was never paid, and as a result, they forfeited it and unpaid tax, interest, and fees. On May the 16th, 2013, defendant filed a petition seeking to foreclose all tax delinquent properties that were forfeited for the unpaid property taxes, including Ralph Alfie's property. On February the 26th, 2014, a foreclosure hearing was held in the Oakland Circuit Court. Ralph Alfie didn't appear. At the hearing, the court entered the judgment of foreclosure that included the property. At the time of the foreclosure, the delinquency had grown to $285.81 because of penalties, interest, and fees. Rafalfi failed to timely redeem the property, which would be to say just to pay the money. So he failed to pay this property when this foreclosure order, resulting in a transfer of the defendants to the property. So it's like, we foreclosed on your property. You have an opportunity to pay the redemption. Incidentally, if you ever want to know in foreclosure, this is such a technical point, but if you ever want to know what foreclosure technically means, what you're foreclosing is a particular right. It's called the right of redemption. So yeah, you have a right to redeem, which is the right basically to make good. So foreclosure, what you're actually doing is you're foreclosing that particular right. So that's why it's called foreclosure, because you're foreclosing a right to redeem. So now you know. Yay. On August 19th, they sold the property for $24,500, and they retained all the money in the excess of the $285 that were actually owed. So $24,214.19 of just surplus. Good times. Plaintiff filed this action against defendants in the Oakland Circuit Court, alleging due process and equal protection violations as well as equal unconstitutional taking. Okay, as to the first part of that, just no. We gave you due process. We sent you all kinds of notices, and there was a hearing and everything. A hearing which you didn't participate in for some reason, and then also didn't pay. So, like, you got your due process. But the second part, yeah. As relevant to this case, plaintiffs specifically alleged defendants, by selling the plaintiff's real property in satisfaction of the debt and retaining the surplus, had taken their property without compensation, because we had more property than you had a right to. You had a right to so much, and you took more than that, and we haven't been compensated for that amount you took. So that's a problem. The circuit court, which is the lowest level court in this exercise, the circuit court granted disposition to the defendants, finding the defendants had not taken any property because they forfeited all interest in their property when they failed to pay due. So the circuit court, which is the trial court in this exercise, because we're not in a federal system, we're in state system, so they're using terms differently. So circuit courts are sometimes they have different jurisdictions of different kinds of courts. And so circuit courts are usually what you call like the lowest level trial court of general jurisdiction. And so they call them circuit courts. They call them that in Virginia too. So when you hear circuit court, don't think circuits like Court of Appeal. We're in Michigan state law. So here we mean the trial court. So the trial court said, this is fine. They forfeited all the rights. No problem. They get to keep all the money. All right, so let's appeal. The Court of Appeals affirmed the circuit court and rejected plaintiff's argument that the scheme allowed for an unconstitutional taking. So the Court of Appeals says this is fine. Drawing on precedent from the United States Supreme Court regarding civil asset forfeiture resulting from criminal activity, the Court of Appeals had the defendants acquire their interest in the property by way of a scheme that did not violate due process, and thus they are not required to compensate them for this property that was taken. So the United States Supreme Court, in its infinite wisdom, wrote once that civil asset forfeiture is not a taking that requires compensation. And so all states have been relying on that ever since. So they have been relying on the fact that they can take the property and not have to pay for it. And so the trial court, circuit court, said, no problem. Court of Appeals says, no problem. So the Supreme Court of Michigan is now your last stop along this road, because this is state law. So presumably this is your last stop. So what does the Supreme Court of Michigan have to say about all this? The parties acknowledge that sale proceeds are often insufficient to cover full amount of taxes due, but when there are excesses from these seizures, those proceeds are used to subsidize the cost for all the proceedings for the year's delinquency as well as any year prior. So the state's justification is that some people are judgment proof, which you would expect. Some people are judgment proof. And so even after we seize whatever we can, we don't get the value out of that stuff. So people owe us money and we seize their property, we seize their cars or whatever, but they don't have any money. So we don't get our value. So we are still in the hole. So our justification for this entire scheme is, yes, we took more money than we did from you, but we were using it to pay for other people's liabilities because we weren't made whole. Now, obviously that doesn't make any sense because my liabilities are my liabilities, not my neighbor's liabilities. If I don't have enough money, that is not my neighbor's problem. And so, yes, there are a lot of people who are deadbeats and don't have enough to pay their taxes. But that doesn't mean that you can go after people who do happen to have enough money and take their stuff. So, now I'm made whole. No, that's what they're trying, but no. Then, after these required statutory disbursements are made, surplus proceeds may be transferred to the general fund, in which case the county is the foreclosing unit. So, in the event that we have more money somehow still, so in the event we do wind up with more money, that's okay. We'll just put it in the general fund. So that's something we can do. Of particular importance here, the statute does not provide for any disbursement of the proceeds to former property owners, nor does it provide former owners the right to make any claims for these proceedings. So yeah, it's to make us whole. Well, what if you're whole? We just use it for general funds. We use it to make the state better. We use it to get ourselves nicer cars and nicer offices and stuff. No opportunity for any kind of corruption here, right? Yeah. A claim of an unconstitutional taking is distinct from a claim of property deprivation without due process of law. In Lingle versus Chevron, which is a different Chevron case that I don't hate with a dying passion, the United States Supreme Court discussed the differences between two constitutional clauses. The Takings Clause expressly requires compensation when the government takes private property for public use. It does not bar the government from interfering with property rights, but rather requires compensation in the event of otherwise proper interference amounting to a taking. Conversely, if government action is found to be impermissible, for example, because it is so arbitrary as to violate due process, that is the end of the inquiry. No amount of compensation can authorize that action. The remedy to be taken for private property is just compensation. while the remedy for being deprived of property without due process of law is return of the property. Notably, the plaintiffs do not dispute the legitimacy of the defendant's authority to foreclose on the property, nor do the plaintiffs contest the adequacy of defendants' efforts to notify plaintiffs of the tax delinquency, forfeiture, and foreclosure. So there are two constitutional provisions in play here, one dealing with due process and one dealing with taking for public purpose. And violations of each of these require different remedies. If your property is being taken in violation of due process, then it has to just be given back. If, however, you were given due process, then the remedy is just compensation, because that's what the Constitution allows for. So if they just take it without giving you process, they have to give the property back. If they take it lawfully, they have to give you compensation. And so the people here are conceding, yes, you did take it lawfully. We did get due process. So they initially tried due process, but no, that's not going to fly. They did get hearings, they did get notices, they did get the opportunity for all the processes, they did get the opportunity to pay, and they just didn't pay. So they did get due process, and now their property's been taken. So this isn't a due process violation. It is a taking violation, if anything. This state's common law is adopted from England, and to identify such law, this court may consider original English case and authority. Our review of English common law supports the notion that an owner of real or personal property has the right to any surplus proceeds that remain after a property is sold to satisfy a tax debt. Just as the Magna Carta protected property owners from uncompensated takings, it also recognized that tax collectors could only seize property to satisfy the value of the debt payable to the Crown, leaving the property owner with excess. In fact, although a mode of collecting the land tax in England was by distress, it was a well-recognized principle that any excess property sold to satisfy a tax debt would be paid back to the owner. Further, Blackstone explained that in the context of bailments, whenever a government seized property for delinquent taxes, it did so subject to an implied contract in law to either return the property if the debt was paid or to repay the render back if the property was sold to satisfy delinquent taxes. So yes, all my sovereign citizen friends out there can be a little bit happy that we are using the Magna Carta as lawful authority for something. So here you go. Yes, the Magna Carta reflects the proposition that property exists and cannot be taken without compensation. We got these ideas from somewhere. And when we go look at these old commentaries and these old cases, and we go look at Blackstone, which describes these old authorities, we see that the old English authorities stand for the proposition that yes, you can take the property, but only for the tax owed. According to these fundamental principles, the government shall not collect more taxes than are owed, nor shall it take more property as necessary to serve the public, protect taxpayers and property owners alike from government overreach. As the foreclosing governmental unit under the law, defendants were entitled to seize plaintiff's property to satisfy unpaid delinquent real property taxes as well as any interest, penalties, and fees associated with foreclosure and sale of the property. But defendant could only collect the amount owed and nothing more. Once defendant foreclosed on the property to obtain title to the property and sold them to satisfy the debts and fees, any surplus remaining belonged to the plaintiff. That is, after the sales proceeds are distributed in accordance of order of priority for debts owed, because it has a system of how much, so it has a system of like the priority of debts. So here's how you satisfy debts. So once you've gone through all those priorities, any surplus that remains is the property of the plaintiff, and defendants were required to return that property to the plaintiffs. Put simply, defendants' argument that the taxing power justifies retention of surplus proceeds from tax foreclosure sales over and above property owners' tax liabilities is an exceedingly poor attempt at disguising a physical taking of property requiring just compensation as an arbitrary and disproportionate tax. Spicy words, but ones that I think are warranted in this circumstance, but way to go, court. Accordingly, when property is taken on to satisfy this unpaid tax debt, just compensation requires foreclosing governmental unit to return any proceeds from the tax foreclosure sale in excess of delinquent taxes, interest, penalties, and fees reasonably related to the foreclosure and sale of the property. Not more and not less. So that is the end of our coverage of the State of Michigan Supreme Court case in the case of Rafalfi LLC versus Oakland County, Michigan. In this case, the city of Oakland seized property lawfully to pay a debt. I'm not sure why this guy didn't pay. He had notices. He tried apparently to pay, but he just wasn't paying that last little amount for some reason. And then they sent him a final notice, which he ignored. They gave him a court case, which he ignored, and they seized the property. So all that was fine. But here's the part that was not fine. They sold it for $24,500. He only owed $250. And then they said, oh, we're just going to keep the rest. And like, what? No. And the trial court said, okay. The Court of Appeals said, okay, but the state of Michigan says, no, you can't do that. So he's going to get a check for $23,000 in change, as he should. And Michigan can't keep doing this. If they want to seize property for lawful purposes because people don't pay taxes, yeah, you can do that. You have to then sell it in a commercially reasonable way. He bought it originally for $60,000, so he's well in the hole. The property apparently lost lots of value, but that's neither here nor there. So yeah, he gets his check for $23,000, and that's the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.